Yeah.
So maybe we can just get started and then people can join as they come in while I introduce you, Agnes.
Okay.
First of all, I'll just start by letting you know that my name is Vinu Sani and I'm a program director at the Law Foundation. I've met not everybody, but most of you at one point or the other, and can't wait to meet you all in person at the next conference. I'll start by acknowledging that we're presenting to you from the unceded territory of Coast Salish people, including the territory of Musqueam, Squamish, and Tsleil-Waututh peoples. And I welcome you to the session today. And it's my pleasure to also introduce Agnes Huang, who many of you have met. Agnes is a family lawyer in downtown Vancouver. She's with Saltwater Law. And she was called to the bar in 2007. She's been a presenter at many of these events, and we certainly really enjoy having her present here. And she's a popular speaker in this group. So Agnes has been a lawyer for a while now, but prior to coming to the practice of law, she has been an activist and very active in the women's community and the feminist movement, including at Vancouver Status of Women, Kinesis, and Women's Legal Action, Women's Education and Legal Action Fund. And she's active on the CBA and Trial Lawyers Association. So welcome, Agnes.
Thank you, Vinu. And Vinu and I go back, way back.
Way back.
We won't say how long. Anyway, always a pleasure to be here with all of you advocates. You are my favorite group of people, even though I can't see you right now. I'm very sad, but I too acknowledge I'm here in Vancouver on the unceded territories of the Squamish, Musqueam, and Tsleil-Waututh nations. And I give honor to them and praise and thank you for allowing me to be here, to live, to work, to play, and to laugh every day. That's my goal. I get to the honor of doing the family law update. And as you can imagine, there are hundreds and hundreds of cases. And I should be frank, often I try to get through as many as I can to try to pick some really good gems. And this year I didn't as much get to hit all of them, but I found some that I tried to find some that I think are relevant to all of you. But I keep saying to myself every year, I'm going to write it out more every year and the ones that I think are good for you. Anyway, so if I get to that, you're always welcome to that. I am happy to take questions at any point if throughout, or ask, for you to share your knowledge as well and your experiences. So I always appreciate hearing from you. But please know, as I said, I can't actually see you on my screen. So if you put up your hand, I've asked either Vinu or Lesia to flag for me that you're on, that you'd like to say something, or you can just speak up. You can just interrupt me and say something if you want to share with the group or correct me.
Agnes, I'm sorry to interrupt you. If you want to see some of the videos that people have on, you might be able to do that if you click on view, which is at the top of your screen on the side. There's like a view button, but I mean, you might not have it, but
it's not so much. I can only see.
All right. Okay.
Because I need to see my PowerPoint.
Okay, no worries. Okay.
You don't want me to try to do this by
That's okay. Don't do anything.
All right. So let's get in. I know we have till 2:30, and I'm hoping to leave enough questions. I have about 15 cases, but there's a couple big ones. So the first one, as you know, the Supreme Court of Canada often does not weigh in on family law matters, but they actually are these days. Last year, there was the big child support case called Mike, Michelle, and Graydon, and I spoke about that last year. And that was about retroactive child support. And it had an amazing concurring reasons for judgment by Madam Justice Sheila Martin. And if you don't know her, she's out of the Alberta courts, but she's also actually been counsel for Women's Legal Education Action Fund, LEAF, on a number of their cases. So she is very strongly a feminist, and you can hear that in what she says. She talks very much about, the best child support. You have to infuse child support with the best interests of children. So it's a really good read. There's a companion case that sort of came out this year in January, and that's Colucci and Colucci. And it deals with the issue of retroactively reducing child support and rescinding arrears. So this is a case out of the Ontario courts. The parties were divorced in 1996. And just so you know, so when the child support order was made, it was pre-federal child support guidelines. Not a huge deal for this case, but just there are those days where things are pre-child support guidelines. Anyway, in the order, the mother was granted sole custody of the two daughters, and the father was required to pay child support in the sum of $115 per week. 2 years later, the father requested to reduce his child support, but he didn't provide any financial disclosure, so the parties never reached an agreement. From then on, he made no voluntary child support payments. And he was fortunate, of course, that his daughters aged out in 2012, so his child support obligation came to an end. But then, probably because they're equivalent of the Family Maintenance Enforcement Program, he called them and says, hi, you've got $170,000 of arrears going, so we want that. So in 2016, he brought an application to retroactively reduce his child support and then rescind his arrears. So the Ontario court judge, the motions judge, said, you bet, let's reduce your child support arrears by $41,642. Now, this is based on the retroactive being like looking at his income over the number of years. I can't remember how far back he was seeking to go. But so at that point, essentially the trial level judge agreed that the arrears should be, the amount should be reduced. So that takes 41,000 off his 170. The Court of Appeal said nope, and ordered the father to pay the full amount of the arrears. So then steps in the Supreme Court of Canada, and cut to the chase, they dismissed the father's appeal and basically put it back to him having to pay the full $170,000. Now, there's a lot of slides that will follow this because the analysis or the discussion from the Supreme Court of Canada is really important. So I really, if you are dealing with child support cases, certainly look at Michelle and Graydon for if your client is trying to get retroactive child support. And look at this case, Colucci, if your client is either trying to retroactively reduce child support, or if your client is trying to defend against an application to reduce child support. Because there's some really important analysis and discussions here. It's like they finally, the big case used to be DBS, but DBS was a particular set of cases that, anyway, there's so much more analysis and discussion here. It's great, finally. So the Supreme Court of Canada held that courts need a wide discretion to vary child support orders to ensure that the correct amount of child support is being paid and to adapt to the enormous diversity of individual circumstances that families face. So there are three interests that have to be balanced in order to achieve a fair result. Number one, and actually this is always a primary factor, the child's interest in receiving the appropriate amount of support to which they're entitled, because as we all know, child support is the right of the child. Two, the interest of the parties and the child to have certainty and predictability. Now, this is both for the payer and for the recipient, right? It's not just the payer having certainty or predictability, but also the recipient needs to know how much am I going to get each month so I can plan my life. And also when you get to it, it's like, if there's a retroactive order and I have to pay back $50,000, holy crap, right? First swear word, I guess. The need for flexibility to ensure a just result in light of fluctuations in the payer's income. So the child's interest in fair standard of support commensurate with income is the core interest to which all rules and principles must yield. Child's interest. So the court said, okay, here's our framework if we're going to decrease child support. First of all, you have to, what's the biggest thing that comes up in child support or spousal support claims? Financial disclosure, right? So the first thing the court says is, look, you need to acknowledge there's what they call an informational asymmetry between the parties. That is, the payer knows what their income is, the recipient doesn't, right? So disclosure is a linchpin on which fair support depends, and the relevant legal tests must encourage timely provision of necessary information. We all know the thing, failure to disclose. Anyway, is the thing that drives the courts over the edge. So if a payer is the one who knows and controls the information. That is the person who has to provide the information. Full and frank disclosure of income. We know from the Family Law Act, Section 5 requires full and frank disclosure, right? So it's built in all throughout. So without full and frank disclosure of income, parties cannot stand on an equal footing required to make informed decisions and resolve child support disputes outside of court. So you can't have an appropriate agreement if you don't have full financial disclosure. And when you get into the court, it's very difficult for the court then to make decisions without full and frank disclosure. They go on and on about these principles, the duty to disclose. It's just tied into the legal obligation to pay support, right? Proactive disclosure on changes to income is the first step in ensuring that child support obligations are, what the heck is that word? Skip. Sorry. I knew there's things. Anyway, so, and then here's like, okay, so how does it work? Now you've got full disclosure. So once you've established there's a material change, and that can be the incomes has changed. And we're not talking about a couple $100s, a couple thousand. It's usually quite significant changes. Then there's a presumption in favor of retroactively decreasing child support. Now you're like, oh my God, it's going to go back 20 years, because now he's given me all his tax returns for the last, since 2000 and he didn't make that money. Don't worry. Well, worry a bit. But there is what we call the presumptive date of notice, like the date in which the court will go back to for retroactive support. There are many cases that I've read in BC, and I've even tried it, where a party is trying to actually get retroactive all the way back as far as they can go. And this Court of Appeal, Supreme Court decision sort of puts a halt on that, right? That the courts aren't just going to say, okay, well, you haven't disclosed for the past, 10 years. Fine, we'll just adjust everything. The Supreme Court says, no. Basically, the date at which we go back to for the retroactive review is when the payer gives effective notice. And it's also only up to 3 years before formal notice of the application to vary. So really 3 years is your marker. So what is effective notice? That's when the payer gives clear communication of the change of their circumstances, accompanied by, this is key, a disclosure of any available documentation to substantiate the change. So it's not enough for the payer to just say, hey, I just lost my job, so I'm not going to pay any child support. Can you sign on the dotted line so FMEP will get off my case? No, you need to have proper documentation. That could be, why the person lost their job, what are they doing to look for new jobs, et cetera, right? So it's not enough, as they say, for the payer just to merely broach the subject with the recipient. There has to be more than that. There has to be docs. So in the absence of effective notice, then certainty and predictability for the child are to be prioritized over the payer's interest in flexibility. So if there's no effective notice, you don't go back and give the payer an out, because then that may mean that there's going to be a reduction of child support to make up for overpayments, for example. And that will put the child and the recipient in a very precarious situation. As the Supreme Court says, the recipient is entitled to rely on the court order agreement in the absence of proper communication and disclosure by the payer, showing a decrease in income that is lasting and genuine. Lasting is, it's not just, some people say, the courts here had a process for emergency cases because of COVID, if people lost their jobs, but it wasn't meant to be long lasting, that was it. The expectation was when the COVID situations sort of normalized a bit, or people could go back to work, people would have to start paying their support again. It wasn't meant to be a permanent change in the support payable by the payor. And also genuine. Again, somebody quits their job and says, oh, my income went down. I just didn't feel like working here. I'm going to instead, open a ice cream stand, at the beach, and my income will go down a lot. That's probably not very genuine in terms of how the court would see the reason for the decrease in the income, because the payer has control over the date of notice and the date of retroactivity, because the payer is the only one who knows when their income decreases. So as I said earlier, even if the payer gives effective notice, you're still only going back to 3 years from the date of formal notice. I'll get to the exceptions to that. And the reason why there's this, what they call the presumptive 3-year limit, is because it allows parties to negotiate, but recognizes that the payer must commence proceedings in a timely manner to protect the certainty interests of the child and the recipient. The court does have discretion to depart from the presumptive date of retroactivity, where the result would be otherwise unfair in the circumstances. You have to compare this also to when a recipient is seeking to increase or is seeking retroactive child support. Although there's this whole notional is only 3 years back, the courts will also go back further more readily than they will in this case, because the recipient generally doesn't have the income information for the payor. So won't necessarily know how that they could go back. If they find out, wow, 5 years ago, you got this brand new job and you make now $100,000. I didn't know that. So the courts are, in those cases, give more leeway to going back further than 3 years. In this case, it's the payer who has all the information. So they should be able to know, them being able to figure out the 3-year clock is a lot easier. So that's why the presumption of the 3-year limit is more stringently adhered to than on the other side of seeking retroactive child support. So there are 4 factors that were in DBS, and they have been adapted to suit the retroactive decrease context. So one, they look at the payer. Does the payer have an understandable reason for the delay in giving effective notice or formal notice? And this is an important one. The recipient's delay in enforcing arrears is irrelevant. So the payor can't say, well, she didn't ask me for it, or she didn't come chase me. She didn't go to court and make me pay more. Too bad, irrelevant. The payer's conduct, which includes efforts to disclose and communicate with the recipient and to make genuine efforts to continue paying as much as the payer can. So if a payer just decides, oh, my income went down, I'm just going to pay $0. And they could have paid $200 or $300 versus $600. The court won't look kindly on that. That's one of the factors that will go against the payer in terms of the payer's conduct. Third is the circumstances of a child. So for example, if the child's experienced hardship or is it currently in need? If that is the case, that factor militates towards a shorter period of retroactivity, not back 3 years, maybe we'll give you a year. And here's a big one, as we talked about, the circumstance of whether or not a recipient would be required to repay support to remedy any overpayment. It's rarely appropriate to do a retroactive decrease in support to the date before the recipient could have expected that the support payments might be repaid, because it puts the recipient in a place where, they was finally on living with what they had, budgeting accordingly. And usually with child support, it's not like you get to bank a whole bunch of it. You spend it on your kids, that they would have to pay any of it back. And so that's why the courts will be more stringent in sort of like how far back we'll go will also depend on what's that impact going to be on the recipient if there's any overpayments. And the reality is payers only often go back to do retroactive is decreases because they say there's an overpayment and they want money back. And hardship for the payer, if the period of retroactivity is not lengthened beyond the 3 years. And this is, again, an evidentiary issue where the payer has to establish real facts supporting a finding of hardship. And where the payor has basically done it to themselves by failing to disclose, for example, or give notice to the recipient, the courts are less inclined to grant an extension of the retroactivity period based on hardship. And finally, the Supreme Court of Canada talks about rescinding the arrears, which was something that the father in this case of Colucci was also seeking. And the court says, be very clear, it has to be based on not only a current inability to pay. It has to be based on the current inability to pay. And that's the only relevant factor. Based on the current inability, the only relevant factor is the payer's ongoing financial capacity. So it's not just right now, if the payer can pay, but also looking into the future, whether the payer could pay. And so again, onus is on the payer to show sufficient reliable evidence to allow the court to assess what their current and prospective financial circumstances. So the payer will have to do a lot of work. It's not as simple as, hey, look at how bad my income was, over the last few years. Give me a break, right? Okay, so there is a presumption against rescinding any part of the arrears. And generally, when there are arrears, it's because there's a court order or an agreement, right? And parties are expected to comply with that, and recipients are generally relying on it. And so the presumption can only be overcome if the payer can establish on the balance of probability that, this is key, even with a flexible payment plan, the payer cannot and will never be able to pay the arrears. So it's not just, as I said, now I can't pay the arrears, or maybe in 2 years I can't pay the arrears. It's like, well, you have to show that you will never be able to pay the arrears. And so they'll keep the arrears alive. If in the event you win the lottery, for example, you get an inheritance, you get a good job, right? So rescission arrears is a last resort in exceptional cases. So what happened in Colucci? Well, I already told you. Do you remember? It was about 15 slides ago. Anyway, the Supreme Court held that the father's deficient communication, his inadequate evidence, and insufficient disclosure were fatal to his application for a reduction of the child support retroactively, and also to his application to rescind arrears. They noted that his conduct shows bad faith efforts to evade the enforcement of court orders. You remember, he didn't pay anything from 1998. Boo. Okay, anything on child support before I move on to parenting time? I know that was a huge verbal blah for you to start your afternoon. Parenting time. So the parties have an 8-year-old son, and the mother had been diagnosed with cancer. And this is the key. She was a proponent of homeopathic, holistic, and natural remedies and therapies. Now, imagine the judiciary and what they generally think of such things, and people who believe in that. What do they think about Gwyneth Paltrow? Yeah. Well, okay. So the father deposed that the child told him that the mother made the child urinate in a jar, and that she then put some of the urine in a smoothie for him to drink. The father said he found jars of urine in the bathroom. The father also alleged that the mother does not believe in COVID-19 and is an anti-masker and an anti-vaxxer. Okay, you can imagine where the master's head is going. Yeah, and it goes there. So the mother deposed that she never used urine therapy on the child, and she never puts urine in his food or drinks. She said she gave the child a jar to pee in order to monitor his lymphatic system, to check if his kidneys were filtering. Why? Because, and this is a complaint by some parents, the father was primarily feeding the child a diet of high fat, high sugar, and high salt, leading to her to be concerned about the child's health. The mother said, look, he pees in a jar. I shake it around for a while, let the sediment go down, and I check, all good. And then she dumps it in the toilet. That's what she says she does. Well, Master Robertson found that both parties exaggerated in regards of the wrongdoing of the other. Now, because this is all done by affidavits, right? So there's nobody giving oral testimony here. But then Master Robertson decided, I believe the father's evidence more because I found it more balanced and centered on the child, while the mother was more focused on defending her health beliefs and minimizing their effects on the child. The mother also did a lot of stuff on social media that the master didn't like and the father didn't like. And she, posted things and I'll tell you, well, here we go. He notes a number of factors that he says undermines the mother's credibility, including that there was independent evidence that was contrary to her evidence. For example, the child's family doctor had reported that the child said to the family doctor that there was urine being put in his food. Now, in the course of his reasons for judgment, Master Robertson does note that the child recants at various points and says, no, that didn't happen. The mother's evidence in respect of her beliefs as to the health benefits of urine therapy are rife with opinions and unproven therapies. I mean, this is probably the language that would come up when a parent is opposed to the COVID-19 vaccine if it went to court. And this is an interesting one for feminine. Her use of extreme language and adjectives such as gaslighting, narcissistic abuse, terrorizing, and dictatorship suggest exaggeration. And Master Robertson noted there's often no factual description to support such adjectives. I'm going to clean these slides up. My apologies. How many times do our clients talk about, their ex being gaslighting them, being narcissists, terrorizing them, harassing them, and so forth? And here's the judge is like, this stuff isn't real, right? And it's hard sometimes because, of course, when your client sort of describes what's going on, and the other side, in this case, the father, is just like, no, that I don't do any of that. The judge decides, well, I believe them generally. I believe the father more generally in many things. So therefore, this kind of conduct, I don't believe happens, right? That's very clear in here that the master has an impression of the mom based on the affidavits. And then the master points to the mother's friends' affidavits, basically calling them self-serving. And it doesn't appear they were aware of the allegations being made against either party. That is, for example, they weren't told that the mom apparently, puts urine in the kids' foods. And then the affidavits were ripe with opinions and superlatives, like she's the best mom ever, which really should never go on an affidavit. And I know all of you know that. So Master Robertson concluded that the mother was acting in such a way that her judgment, particularly as to health matters and the risk of urine therapy, constituted exceptional circumstances to warrant supervised parenting time. Whoa. If you've heard me before talk about supervised time, you know how sort of narrow it's supposed to be, the grounds in which, it's supposed to not be used except sort of close to last resort kind of thing. Anyway, but apparently the mother who had been parenting this child was a risk to her child. The funny thing is, okay, how does this work? Then the court orders that the mom would have parenting time from here, Sunday at 6 to Wednesday at 6. Sunday, Monday, Tuesday, Wednesday, 3 full days, supervised by a professional supervisor or a third party agreed to by the parties. So basically, and the master doesn't say who's paying for a professional supervisor, but they're supposed to find somebody who for 72 hours is going to hang out with the mom and kid, including sleepovers, and have to probably stay awake because the only way you can supervise is if you're awake, right? So it's an interesting case. I'm interested because I don't know if you have clients I do have some clients who are, they either don't believe in having COVID vaccine shots or perhaps vaccinations in general, and certainly not for their children, and certainly not necessarily ever, but sometimes it's until there's more research, right, on the side effects and the potential damages that could cause people or children from these vaccines. And I've had to tell clients, it's like, I respect your position, but you have to know if it goes to court and your ex makes an issue of it, and you not agreeing to either vaccinate yourself or your children if they're able to be vaccinated, and it causes the children, for example, not to be able to go to school or participate in activities, or it could put their health at risk, I can tell you where the court will go. The court will side with the parent who will do those things, because just like general vaccines for measles and so forth, you're not going to find a judge being convinced that these are not appropriate medical interventions for children. So, some of my clients have very strong beliefs about things, and I respect that. But I do have to tell them how it could play out in court if they continue with their position. And like many people, like healthcare workers now, and so, who have their mandatory vaccination, they have to make those decisions in their best interest. So anyway, moving on to some parenting arrangements. This is a case called Aujla and Gill by Madam Justice Gill, Supreme Court. There are 4 kids, and they resided with the mom since separation primarily. And part of the separation arose from the father's alcohol dependency. But when they separated, which was 2015, but for about the last 3 years, so leading up to 2021, he's been sober. Now, the parents don't agree on a number of things, including homeschooling. The mother, who had primary care, was homeschooling the kids, and the father didn't want that to be the case. After he became sober, so a few years ago, he was able to have parenting time with the children, but it was supervised by the mom. Then at the start of COVID-19, as you know, it screws up a lot of the parenting plans that people had in place. And that was the case here, where the father experienced difficulties exercising parenting time, not only because of the pandemic, but also then the children started to become distant from him. And the mother, he said, was not actively encouraging the children to cooperate in coming to him. Now, they're not little kids. They're sort of that 7 to 13 range. So, you know, there's some closer to the tweenie age. So then what happened also sometime in late 2020, under cover of the pandemic and wearing their masks, the mom moved with the kids away from the Lower Mainland to Kamloops. Kamloops is lovely, by the way. And then the court, so Madam Justice Shergill actually presided over a trial that went from like November to May. And in November, sort of as the first set of dates ended in trial, she ordered a Section 211 report. And I think in January, when they came back, she ordered, you'll see some other unsupervised parenting time. So there was a Section 211 report done by Dr. Elterman, who found early stages of parental alienation. He also concluded that the kids were doing really badly at school, and they had problems with their motor skills, and they weren't being treated for that. They spent only an hour a day in school and didn't have a structured education plan. And so he didn't recommend homeschooling. Dr. Elterman also recommended that there was no risk to the kids from the father, and that the parent should move towards a shared parenting regime. So what happened was, as I said, the trial sort of like had a number of days. And so in the middle of the trial, Madam Justice Shergill made an order for unsupervised parenting time for the father. And she also, this is in September, also ordered the mother to return to the Lower Mainland with the children. So and she had till, I think, January of 2021 to do so. So sorry, the trial didn't start in November, it started before. Anyway, the court found the father to be credible and reliable as a witness, and the mother not to be. Madam Justice Shergill found the mom to be woefully unequipped to homeschool the kids, and that her motives were motivated, her moves to different places were motivated by her desire not to co-parent with the father. So rather than co-parent with him, she fled. The court gave little weight to the children's expressed desire not to see their father because of the negative influence of the mother in shaping their opinions of the father. Madam Justice Shergill found that the mother's conduct did not reach the level of parental alienation, but she was on the path towards it. And she found that the children's emotional well-being was better served by increasing their time with their dad, with the goal of reaching an equal shared parenting. On the issue of education and health, the judge found that the father was better equipped to meet the children's needs and awarded the father final say in decision-making on those matters. The court and the father wanted conduct orders against the mom, which she consented to, which included things like she was to encourage the children to have a good relationship with their father, and that she not talk negatively about the father, and a few other things. As judges are very prescient, Madam Justice Shergill was expecting that things could go off the rails, and so she seized herself in the matter for 1 year. Okay, that's that. I guess that's a good case if you want to. I mean, it's a case where obviously there's if you want to sort of see sort of. It's not the same, obviously, every judge. Facts are all different, but sort of like parameters around when a court might flip the parenting regime and flip the decision making. And this is a case where the court's like, yep, we either have to intervene. So the court's being quite interventionist here in doing so, in that the children have been with a mom all the time, and it's basically flipping it. So even though the court doesn't find alienation, the remedy is almost like they did find alienation. They found enough of the mom having done something, the judge did, that warranted basically flipping the power towards the father. Imputation of income. I realized my slides are a bit out of order because I have some more parenting stuff below. But anyway, I wanted to talk about this because there's a couple BC Court of Appeal cases, this one being French and French. The parties were involved in a family law proceeding a few years before, and they dealt with the division of property and then spousal support. And the wife, a few years later, brought an appeal of the decision around particularly spousal support, alleging that the judge had erred in calculating the support payable to her because the judge based it on imputing income to her prior to a motor vehicle injury she had sustained, which left her unable to work. So the judge acknowledged, yes, the wife can't work now due to a medical condition, but hey, still attributed a pre-accident income to the wife, which then reduced her entitlement to spousal support to zero. And the reason the judge did so was because the judge said, well, at some point you're going to get compensated by ICBC. Well, who knows nowadays with what's going on with that system, so that she would get that income back for that sort of lost income. And that was the expectation. So therefore, basically imputed that income to the wife, said, oh, well, that she has this amount of income, even though she didn't have that money at all in pocket, and there was no timeline which she was actually going to receive any compensation, or if she was actually going to be fully compensated for her loss of income. I digress. But the judge says, yeah, I'm gonna give you that income. The Court of Appeal says that's wrong. That's an error in setting the wife's income at that pre-accident level on some expectation that she presumably would be compensated for loss of income. The court held that the prospect of reimbursement at some point in the distant future, and they use those words, in some point in the distant future, does not represent a proper basis for imputing income to someone who has not received that income. And so the Court of Appeal allowed the wife's appeal. So courts are very mindful about things that are speculative, right? They want real evidence, real and now, that can be substantiated. And so this is a case where it's speculative that the wife is going to get money back, and therefore she doesn't, and once she gets all that money back, she doesn't need support. Even if it was going to be like, 4 years from now, she has zero income now anyway. So the Court of Appeal fixed that. Here's another case of imputation of income. This case, M.F.W. and M.A.H, Mr. Justice Basran. So after a trial in 2019, the husband was ordered to pay child support and spousal support on an annual income of $170,000, which was derived primarily from the company he had invested in. And he had inherited several $1 million of assets, which included this company a year prior to the end of the marriage. And then in December 2020, he was laid off from the company, and he sought to reduce his support payments and cancel arrears. He basically, I got zero. Hey, oh, there we go. Oops. The court denied the husband's application. Mr. Justice Basran noted that this is always the one, when you fill in the financial statements, he had $67,000 of annual income, but had $13,000 in monthly expenses. I don't know why they didn't do the math. What's 13 times 12? Anyway, it's a lot more than $67,000. So, and there was no corresponding increase in debt, right? So either the father was lying about his expenses, or he had a lot more income, or the husband had a lot more income than was stated, right? He also couldn't give, or didn't give, any proper explanation why his assets were worth millions of dollars, seemingly generated no income, right? So that raises a lot of red flags. And then in terms of his health, the husband failed to prove that his health problems impaired his capacity to work. He had worked as a heavy equipment operator in construction, and there wasn't enough healthcare medical evidence to show he couldn't continue to work in that capacity or in anything else. So the judge found that the husband was deliberately underemployed and imputed not the $170,000, but $125,000 to the husband. So there was an acknowledgement by the court that his income went down, but not basically to zero, which is pretty much what the husband had wanted. And no income was imputed to the wife. Regarding canceling arrears, which the husband had wanted, Mr. Justice Basran held that despite the significant decline in his income, this is again what the Supreme Court talked about in Colucci, it has to be long-standing, not just right now. There's a decline in income and there's just no cash to pay it. So it's uncertain that it would be longstanding, and there was a paucity of evidence of the husband's efforts to obtain employment. And also, given his lack of financial disclosure, the judge wasn't satisfied that it would be grossly unfair not to cancel or reduce the arrears owing. Grossly unfair, of course, that's the test that continues to go for him. So that's another one about somebody being underemployed, a case that if you want to rely on, there it is. Okay, without notice orders. So the parties were married in 1998. They separated in 2020, but they remained living in the same home. The wife sought and was granted by Master Scarth an ex parte order for exclusive occupation of the house, a protection order, and a financial restraining order. Once she got those orders, particularly the exclusive occupation order, the police came, took the husband out of the house. In support of her ex parte application, the wife deposed to the long history of family violence during her marriage. And this included having to flee to a women's shelter because the husband had assaulted her, or he had threatened her. And so he was charged with uttering threats and released on undertakings. After he was arrested, the wife said that the physical assaults went down, but then he was doing other things, like he'd spit on her, he would degrade her, and he would call her a prostitute. Anyway, but the oldest child too, who was around 20 at the time, also deposed that the father had physically, verbally, and mentally abused him throughout his life. And this is interesting that Master Elwood doesn't seem to take an issue with this child. I can't remember, the child could have been 19 or 20, like around that age. I can't remember. I don't think it says how old the child actually was when the child swore this affidavit, or the young adult. As you know, many courts sort of poo-poo the idea of having children, and obviously young children, but even as they get older, the older children engage in these family law proceedings. And so there was no comment, though, from Master Elwood about whether or not it was appropriate for the eldest child at age 20 to make an affidavit in this proceeding. And anyway, sorry, that was Master Scarth, pardon me. Anyway, the matter all comes back before a full hearing with notice to the father before Master Elwood. And the father, of course, seeks to set aside the orders, and the wife wants to extend the orders. So the court finds that the husband wasn't credible, and that was, for example, it was highly improbable for the wife to fabricate the detailed evidence of family violence in her affidavit that were in her affidavits. Master Elwood found the husband to have very little self-awareness about his behavior towards his family. So not just his wife, but his kids, the two kids. Master Elwood found that the wife's application should not have been made without notice to the husband. That he should have been allowed to put his arguments before the court. And the master cited a recent decision from the Court of Appeal, Kaur and Makar, where the court describes without notice orders or applications as, an extraordinary, powerful interlocutory remedy, which is recognized as having the potential to inflame a dispute between parties in fraught situations. What was Master Elwood's solution for what did he say the wife should have done? Basically, he said that the application for exclusive occupation of the home should have only been made without notice if there was actual urgency or real possibility of violence if notice was given. Okay, you remember there's a history of violence, right? Real violence. The court noted, though, that the parties had lived separately but in the same home for, at this point, over a year, and that while the wife swore her affidavit on April 22nd, she didn't bring her application for exclusive occupancy and a protection order until May 4, 2021. So that is, the parties continue to live together in close proximity for 12 days. Hence, where's the urgency, right? Master Elwood said, if the wife said, yes, the wife had reason to be concerned about how the husband might react if served with an application. But then he went on to say, what she should have gotten was a temporary protection order, not for him to stay away from her or to be out of the house, because, that's essentially what a protection order does, is keeps them away from you, but just in order that he not communicate with her directly about the matter until the application could be heard. And that would have been preferable to without notice application from Master Elwood's perspective. Would it have been safe for the wife? I'm going to give you hands up, and I'm sure I know how many hands are going up at this point about whether it's not safe for the wife. It wouldn't have been safe for the wife, which is why she went ex parte. So he didn't seem to have it. And it wasn't like he said you should get a full protection order, because of course the protection order essentially will do the same as an exclusive occupation order, right? It will get the person away from where you live, i.e. the family home. Same thing, exclusive occupation order. Anyway, his thing was, it was obviously the without notice order, poor hubby, resulted in a sudden and no doubt traumatic police removal of the husband from the home. Anyway, I will leave that for you to digest. I'll leave it at that. So, to me, that's a problematic reasoning. The reason why you go ex parte and you get protection orders or exclusive occupation orders are for actual protection against risk of family violence. And clearly, even though Master Elwood acknowledged, obviously in the back of his head, because he does, just to be clear, he does grant the wife, a protection order and exclusive occupation of the house after hearing all the evidence. He says that she shouldn't have done it ex parte. And the purpose of ex parte is very much because it is a volatile situation. And the fact that she waited 12 days before actually going in, she's basically waited many years, one could say, since like the first assaults and how long ago, and the police intervention in 2013. Is she to be criticized for that? No. I mean, there are many reasons why women won't take those next steps, because they know how more volatile it gets after separation and after taking such steps like that to get a protection order. So anyway, so put that aside. So I was talking earlier about affidavits by a 20-year-old. Well, here's a case that involves a 16-year-old and about the child's testimony. And this is Madam Justice Shergill again. This is T.A.O. and D.J.M, 2021 BCSC, 1690. Just can read it. I don't need to read it. So the parties have two kids, a 7-year-old and a 16-year-old. And the 16-year-old, though, was a stepdaughter of the father. After the parties separated, the mother was concerned that the father had been sexually abusing the younger child. And the mother was told by the older child, the stepdaughter, that the respondent had touched her sexually several years prior. The respondent, of course, denied the allegations. The ministry and the RCMP were involved, but no charges were laid in relation to either child. A Section 211 report was done, but there was no issue about safety concerns of the younger child being alone with her father. So before Madam Justice Shergill, the claimant mom sought to have the 16-year-old testify. And the judge allowed the application for the 16-year-old, to be frank, almost 17-year-old, to testify at trial. The judge noted that the Family Law Act does not preclude a child from testifying, nor does it require a child to testify, which is true. And when I say that judges just don't like children swearing affidavits or being asked to testify, it's because I don't think they want to deal with a kid, but also it is traumatic. It can be traumatic to a child to be pulled into this essentially battle over them between their parents. So why did Madam Justice Shergill say, yes, S should testify? Because the courts need to determine the credibility of both the respondent and of S, which would be difficult doing so on the basis of hearsay statements of, basically of S, mostly of hearsay statements of S, like what S is saying. Now, S had sworn an affidavit in this proceeding, but she wished to testify out of concern for her sister's well-being, N. Madam Justice Shergill found that based on the affidavit material, and not just of S, but presumably the mom and other people, that S was mature enough and old enough to understand the consequence of giving oath to tell the truth. So she granted, as I said, she allowed S to testify, but she also granted some what she calls testimonial accommodations. Namely that, and this, she drew a lot from the criminal law proceedings where a child who's been a victim of violence, particularly sexual abuse, doesn't have to testify in the same room as the person accused of the abuse, right? There are sometimes there may be screens, or sometimes they appear in another courtroom on video. So Madam Justice Shergill drew from that and said, okay, S can testify outside of courtroom, but has to be in the courthouse or in a neutral, secure location, because the proposal was that S be at the mom's boyfriend's home, like a private home, and testify from there. And Madam Justice Shergill said no. S could also have a support person, but there also had to be an independent observer to ensure that S wasn't being influenced by anyone or relying on written materials. So it's like invigilating an exam. Also, the respondent, stepdad, was self-represented. And Madam Justice Shergill says, no way are you going to be able to cross-examine S about these allegations. So the deal became that the mom would pay $1,500 to the dad in order for him to get legal counsel to conduct the cross-examination of S. And that if there was anything above that amount, oh my God, it was going to be covered by the dad. So I recently came across this case. I hadn't seen it before when I was doing my other presentation on parenting, but this is a very, I think, important case in terms of maybe some of the scopes around getting evidence from children directly in through themselves. Okay. So it seems to be a 16, 17-year-old. The court seemed to accept an affidavit. The court previously had accepted an affidavit from this child and then was prepared to qualify the child as being mature enough to actually testify. Now, you remember, because it's coming through affidavits, the judge hasn't actually met the child, right, or interviewed the child. It's just based on what is, written in documents right now. So anyway, I think it's a really important case to hang on to if it comes up for you that you're wondering whether or not a client's child should be brought in to testify. I think we have to do it. You'd have to do it sparingly. It's not, like kids often are like, I want to talk to the judge. It's like, no. Because it also can backfire on your client too, right? So who knows what kids say. Anyway, one last thing. Madam Justice Shergill said, she's very reluctant to have the child participate, but to ensure that S is not being pressured, she makes these additional orders. So prior to the commencement of S's testimony, she will be required to confirm to the court that her decision to testify is voluntary and instigated by her. She should not be testifying because she's been told to or asked to testify by any parent, relative, friend, or legal counsel. And the request to testify should be at her own instigation because she believes that this court needs to hear from her. So that's another safeguard that Madam Justice Shergill put in, because she doesn't want, the child's on the stand being cross-examined or whatever, and just like, I don't want to be here, or blurt out, they made me do it, right? So this is again about protecting the child and also the process and the evidence. Parental responsibilities. This is an interesting one. This is about, who gets to make decisions around religion. 41, is it E or F of the Family Law Act? Anyway, Judge Munstock, Provincial Court, A.J.H and K.J.H. So the mom and father are both Christians, but they have very different spiritual beliefs. The father is fundamentalist Baptist and believes in a literal interpretation of the Bible. So what do you think the father believes in? Well, the father apparently believes that Canada should reinstate the death penalty for homosexuals and that homosexuals should be put to death. And also that the wife has a duty to obey her husband and that women should not speak or teach in church. There are more, but that I picked out some of the highlights. And the father, of course, wants to teach his children these views of the Bible so they can thrive and have the same firm foundation and stability that he does. And the father believes the mother's religious instruction is harmful to the children and not in their best interests. So what does Judge Munstock have to say about this? Well, Judge Munstock granted the mom the authority to make decisions respecting their religious and spiritual upbringing. The judge was concerned for the physical, psychological, emotional safety, security, and well-being of the children if the father were to participate in their religious and spiritual upbringing. Now, that phrase, physical, psychological, emotional safety, security, well-being, remember that is section 37, sub 3 of the Family Law Act under best interest of the child. No order is in the best interest of the child unless it protects, boom, those things, right? So Judge Munstock gets that. Hey, I'm sorry, that wasn't being cheeky to Judge Munstock, but yes, says, this is what it is. The judge found the father's views to be antisocial and said they will cause children to be unable to get along with a large number of people. Yes. And he also ordered that the father's parenting time would have to be in public so that the father has little opportunity to teach his religious views to the children. So what was happening was the father would, for example, they'd meet at McDonald's, the father and the kids would be there and the mom would be sort of nearby. And it was just these are younger kids too. So, sorry. So anyway, I found that sort of an interesting case that came out. It's not surprising that that would be the outcome. I'm going to guess that you would all agree that this is an outcome that makes sense. These are similar when there's those freemen on the land who come before the court. These are the kind of orders that get made as well in relation to them. Termination of guardianship. We have one. Yay, a new one. 2021, Mr. Justice Gyashi. So the mom wanted to terminate the guardianship of the respondent father. There have been several incidents of family violence by the father during and after the relationship. He engaged in conduct that was abusive, harassing, threatening, and the mother had to seek a protection order, which the father breached. He sent hundreds of abusive emails and texts and other harassing messages to the mom. And in fact, he got charged and pled guilty to criminal harassment and was sentenced to time served, which at that point was 265 days plus 3 years probation. So bad guy. Mr. Justice Gyashi goes, well, first of all, terminating guardianship is a draconian step and should only be ordered in the most extreme circumstances and only if the concerns cannot be addressed through the allocation of parental responsibilities, citing a bunch of cases. Okay, we've heard that before. So then what does Mr. Justice Gyashi find? Okay, he says, the circumstances of the case are extreme, but they're not so extreme that the father should be removed as a guardian. So the test now has gone to the standard really high. That's pretty high. 265 days in jail, hundreds and hundreds of emails, ongoing barrage. That doesn't get you over the terminate guardianship hurdle. Because, the consequences of being terminated as guardian are so significant in the eyes of Mr. Justice Gyashi. Because the father would lose any opportunity in exercising parental responsibilities and parenting time. And more importantly, the children would lose the prospect of a future relationship with their father. How does one comment on that? Should they have a relationship with somebody who does all the stuff he does and doesn't seem to be remorseful for what he does? Anyway, that's what the judge found. He says, hey, maybe the father can address his issues by attending counseling and seeking other professional help. And hey, if he does, he should have the opportunity to come back to court and say, there's a material change, I'm a good guy now, and resume his role of a supportive, caring, and nurturing father to his children. And that would be the best interest of children. And hence, termination of guardianship denied. Oh, I thought that was my last slide. Damn it. I thought I had a good conclusion there. Anyway, the judge found that it wasn't necessary to remove the father's guardian because, of course, the mom was going to be denied, given all the parental responsibility, and the dad was going to be denied all parenting time. So the kids are supposed to have a relationship with the father, but the kids will have no parenting time, no time with the dad, and the mom will still make all the decisions. But hence, you just keep them as a guardian because something might change. I don't know. Anyway, so the test obviously became quite high to be able to terminate guardianship in this case. Relocation. I know you all love these relocation cases. Oh my gosh, I'm not just over halfway through. So this is a case, Barendreght and Grebliunas. Thank you. So I'm using mother and father. There are two children, both under the age of 6, I think 3 and 5. Trial judge allowed the mother to move to the Bulkley Valley to Telkwa, yay, Bulkley Valley, from the Okanagan. They're 1,000 kilometers apart. Two primary considerations were the financial situation of the both parties and also their relationship with each other. Not so good on both fronts. They'd owned a home, they had significant mortgages, the house needed a lot of renovations, and they basically struggled to make ends meet. The father worked as a carpenter and the mother had various janitorial jobs. So the father appeals the decision, and he also wanted to, in his appeal, bring in new evidence about his financial circumstances, which he said, hey, it's gotten better. And what he says there, because the issue was that he couldn't afford to keep the family home. And that was one of the reasons why the judge says, yep, you're not going to have a home. Mom gets to go up to Telkwa, where she has some family. In the meantime, what happened was the dad's parents moved wherever they were, to Kelowna. And they also helped him by buying out half of the interest in the home so that they were able to pay out the mom for her interest in the home. Plus, the dad was able to refinance the mortgage. So his mortgage payments went down. And then his parents were able to increase their line of credit so they could do the rentals of the house. So these are the new evidence that the father wanted to bring to the court, saying, look, stable financially, all good. The court said, yep, we can rely on this new evidence. And they also allowed the appeal. And why? Because the court held that the new evidence displaces the trial judge's concerns about the parties' financial positions and the father's ability to remain in the family home in Kelowna. And then aside from those concerns, the Court of Appeal said the remaining circumstances indicated that the best interests of the children were served by the children returning to the Okanagan under a shared parenting regime. They found the number of factors that favor the Okanagan, and I grew up in Kelowna, so I know a few of these factors, but they all stem around cherries. That's the reason to be in Kelowna. Both parents, I'm my parents, sorry. Hi, Mom, Dad. Both parents are good parents. The father has a strong bond with the children and has taken extraordinary steps to manage his schedule so he could be engaged with the children. Oh my God, this is one of those, a dad gets credit for like adjusting his schedule so he can spend time with his kids. And you know how many moms never get any credit for that. And they do it all the time. Anyway, they work miracles beyond extraordinary steps. Boo. The children had always lived in the Okanagan, fair point, and the father's parents had moved to Kelowna. And the mother didn't move to Telkwa to advance her career, to better her educational opportunities, or because she had a new partner there. And she did have some family there, but she just wanted to get away from the situation with the father, really. There was no suggestion that the Bulkley Valley had more benefits for the kids, or different benefits than were available to them in Kelowna. And the Court of Appeal noted that the trial judge had allowed the move partly because he was concerned of the father's past and future treatment of the mother, and found that, yes, the father was an overbearing personality and the mother had been subjected to emotional abuse. The court noted that the mother didn't actually argue that his hostility was one of the reasons to support her being able to move to Telkwa. And in fact, the mother had said things had gotten better after separation. The court said it's significant that the conclusions arrived by the trial judge that the mother's need for some emotional support and concern over the father's behavior have generally not on their own supported a relocation in the case law. So this is a big one. The need for a parent to be around other people like their own family for emotional support, not enough to tip the scales of relocation. And also the other parent sort of not nice behavior, abusive behavior, again, not necessarily enough to tip it over. You got to really look at all the other factors. So the Court of Appeal here says there's virtually no decision of this court where a need on the part of the moving parent for emotional support, even with some friction between the parties, has justified a relocation. They cite a couple just to sort of say, these, they kind of talk about it, but really pretty much no decisions. So the emotional support need is not a ground to justify, is not part of the, not a need, it won't tip you over in terms of a relocation. Permitting the relocation was inconsistent with the object of maximizing contact between the children and both their parents. Relocation always does that. Just, you know, it disrupts that principle of maximizing contact. That's why relocations are difficult. Anyway, but here they were worried that the relocation is likely to permanently and profoundly alter the relationship of the children and their father. There is no comment about the relationship between the children and the mother, because what if the mother stays in Telkwa? The court can't order her to move down to the Okanagan. Why is it the relationship with the father and the children given priority here over the mother and children? I'm not saying it's a wrong or right decision. I'm just noting that they seem to focus a lot on patting the father on the back. Anyway, this case is actually going up to the Supreme Court of Canada. So it's gotten leave to appeal. And so at some point, we will have a decision of the Supreme Court of Canada on relocation out of our province. How exciting. I'm just going to do a quick one on relocation under the new Divorce Act. Now, I know you've all read it and you all have memorized it. And you know that for the first time that there are actually provisions about relocation in the Divorce Act because there weren't before. And they more or less are consistent with what's in the Family Law Act. This is a case where the mom wanted to move with 3 teenage children to Hamilton, the eldest child starting school at McMaster, and the father was opposed to the move. The father was a bad dude, and so mom and children left the family home. There was a Hear the Child report, and the children reported they were scared of their father and noted the problems with his drinking, and they wanted to live with their mom. Now, the child going to McMaster was under the age of 19, but really there wasn't going to be an order in relation to her because of her age and being out of high school. Mr. Justice Colville in this case noted the father was taking positive steps to improve his situation, such as seeking treatment in relation to his mental health and his alcohol misuse. And he looked at the test of relocation under Section 16 of the Divorce Act, and considering the best interest of the children, he granted the relocation on an interim basis. The father had then conceded that for at least for now, on an interim basis, the children should reside with the mom. The court noted that the case law recognized that relocation is one of the most impactful decisions the court is asked to make, potentially having a long-term impact on children's relationships with the non-relocating parent. And this is, of course, very true when the proposed relocation is far away. And so the cases essentially recommend caution regarding relocation, particularly when it's at the early stages of proceedings and when it would be significantly different from the status quo that the children are used to. Of course, that doesn't mean that the court can't make decisions, but sometimes they'll want to not make the decisions in terms of relocation until there's, for example, a Section 211 report, or there's an actual trial where the evidence can be put forth orally and cross-examined. So anyway, despite all those warnings I just gave you, the judge says, hey, in this case, it's appropriate to allow the relocation to happen. And the judge considered the evidence in light of the new statutory considerations in the Divorce Act, the best interest of the child, the good faith provisions, and those considerations strongly suggest that the children's best interests would be served by moving to Hamilton with their mother right now. There's only 5 minutes left, so rather than going to new thing, does anyone have any questions? I have some on, and I was going to talk about annulments. I had a couple property cases. And actually I was getting near the end. FMEP enforcement. If you don't mind, I'd like to tell this one annulment. I'll be very quick because I know unless people have questions. This one is, this is about non-consummation, the basis of non-consummation. And the husband agreed. So the parties had been married in a civil ceremony, but they delayed consummation until they could have a proper Gurdwara ceremony that according to their culture and religion was necessary. That's what the court says. And this is what the wife testified to. Anyway, that ceremony didn't happen. And prior to that, there was the husband had some mental health issues, depression issues, there's fighting. So they separated. And so the religious ceremony never took place. She wanted an annulment. The Chambers judge says no, denied the annulment because it didn't meet that test of non-consummation. Psychologically incapacity, right? The Court of Appeal said, hey, we're in a multicultural society and our common law principles must be applied contextually in accordance with the cultural norms of a party seeking the annulment. So the Court of Appeal said a psychological incapacity can arise as meaningfully from a sincerely held religious and cultural beliefs as from other forms of psychological aversion, both being contextually a normal, predictable reaction. The court said a true aversion to consummate arising from religious beliefs established a genuine psychological incapacity. So the court says it would have helped, though, if there were in the future, here's a hint, if you're ever trying to do annulment on this ground, to have more precise evidence concerning the party's cultural and religious norms and the manner and the extent to which those norms impacted non-consummation of the marriage. The court granted the annulment. I wanted to do this case because it's quite interesting from Judge Doulis. I quite like Judge Doulis. I find Judge Doulis quite thoughtful in her reasoning. But anyway, this was FMEP going after BB. And BB would order to pay child support in July 2005 in the amount of $670 a month on imputed income of $48,000 a month, a year. At the time of this imputation, BB was in jail. And over the 16 years, really, BB only earned $48,000, I think, once, or didn't earn that amount much at all. And the mother never received any child support from BB directly. It was only when FMEP could garnish, usually from like the federal government, right? FMEP chased BB. I mean, if you read the case, there's like, you know, this hearing, a whole like 2 pages of it. BB had sporadic income due to his intermittent incarceration, his addictions issue, and his poor health. He hadn't worked in 4.5 years. He had carpal tunnel syndrome, and he couldn't return to work as a welder until he had surgery. So he had multiple convictions, and for which he was incarcerated. And he also had fines and restitution. He owed ICBC $120,000. He struggled with addictions his entire life, adult life. He was alcoholic. He'd used cocaine, then heroin. And I talked about his carpal tunnel syndrome. His only source of income at the time of this enforcement action was income assistance. He owed $37,000 in child support, and of that, $13,700 was interest. FMEP wanted his income to be imputed to $25,000 and sought that he pay $400 per month towards the arrears. And hammer, if he failed to make a payment, he was to be incarcerated for 5 to 10 days for each missed payment to be served consecutively. Imagine that, each missed payment. Every single month, add on 5 to 10 days, because there's no way he could pay, right? There was no way he was in position to pay. And that's what Judge Gill found. She said, look, and the big thing, this is why this case is important. She took note of the overrepresentation of Indigenous people in the prison system. She says, hey, I know the FMEP, that whole system isn't the criminal code, but we need to apply the same principles here because they're seeking incarceration for default. So we need to, the court said, Judge Gill says, you need to apply the guidelines in the criminal code, section 718.2 on sentencing principles, particularly in relation to Aboriginal Indigenous people, and the Supreme Court of Canada's decisions in Gladue and M.L.E, right? She said the courts can take judicial notice of the broad and systemic factors affecting Indigenous peoples generally, and specifically to the person subject to incarceration. She found that the systemic and background factors affecting Indigenous people in Canadian society have likely impacted BB. I think she says it likely because I don't think there was evidence that was explored with BB on this issue. Judge Gill noted the difficulties faced by BB arise at least in part from transgenerational trauma and substance abuse arising from the Indigenous people's involvement in colonialism, displacement, and residential schools. She was cognizant also the impact of putting BB in jail on his former partner, the mother, and their children who are now adults, as they're also Indigenous. The judge wasn't convinced that imprisoning BB for non-payment arrears would improve their lot in life. She noted that BB appeared to be on a rehabilitative path, and she didn't want to derail that by imposing a punitive sanction. So Judge Gill was prepared to order that BB pay $100 a month to FMEP on arrears, but she was not prepared to reinforce the order with a jail sentence in default. She said, come back in 4 months and we'll take a look. I don't know what happened in 4 months. Anyway, I think that's a very interesting and important case. And I don't usually find FMEP cases that interesting, but that's one. We are at 2:30 now. So yes. I should probably let you all go. Oh, I wanted to talk about property. I'm just kidding. Hey, property. Just one last thing about the rules. You remember before you could file in any court, you could start an application in any provincial court. There's a case called, it's in the slides, AKB and A.D.W, Judge Gouge on the island. This was a mom who, the mom, dad, and young baby 3 were living in Vancouver. She went to Duncan and started a proceeding there, got a protection order. And then the father was contesting it in Duncan, and Judge Gouge says, wait. Rule 7 of the Provincial Court Family Rules, it's new, says, no. If you have an application, you're seeking orders related to a child, you have to file in the registry that's closer to where the child resides. And this child was residing in Vancouver, right? So Judge Gouge punted it back to the registry in Vancouver. So it's an important case just because I didn't realize that until I read this. I read the rules, but I don't really read the rules. So this helped me go, oh shit, I better read the rules. So just wanted to point that out to you. Anyway, lovely to see you all. I hope you have a great rest of your conference. If you do have any questions, you know, you're always welcome to call me. You know how to find me. You're always welcome to email me. And yeah, lovely to see you on next year in person. I'm open to different themes, so let me know what you want to do. Let me know what you're prepared to do.
Thank you, Agnes.
You're very welcome.
Thank you, Agnes.
Thanks a lot.
Thanks, everyone.
Bye.
Bye.